Court Watch with Alex Sawyer, and I'm excited to bring you the latest episode of my podcast where I am joined by Carrie Severino, president of Judicial Crisis Network and a former clerk to Justice Clarence Thomas. She'll be joining us to chat about the High Court recently issuing a code of conduct after pressure from Democratic lawmakers and activist groups. We'll also chat about some of the big cases the justices heard this month, including a major gun rights case. They also heard disputes over public officials blocking people on social media and a trademark dispute over the phrase Trump too small. After the Thanksgiving holiday, the justices will also grapple with a bankruptcy dispute involving Purdue Pharma, the maker of OxyContin. Hey, Carrie, thanks for taking time to join me and discuss the latest news out of the Supreme Court. I just wanted to touch on, and I know you've been kind of on top of this whole code of conduct issue. It seemed like the justices all united issued a code of conduct recently after pressure from really Democratic lawmakers and activist groups on the left. What did you make of this being made public? What's your reaction to that?
Yeah, so, on the one hand, I don't think it was at all necessary. And this is something that this is really kind of a solution in search of a problem on the part of the Democrats. They're trying to find ways to smear the court's name and have an excuse to enact legislation that would give them a kind of veto power over who sits on cases rather than let the judicial branch be independent. I think they were behaving perfectly ethically before. And so that's why I think it's challenging here. That I hope that people don't get the impression by the fact that they were issuing the code of conduct that there was actually something missing, because these are the same rules they've been following for decades. This is just the practice of the court. But right. I do think it's helpful for them to have it out there, because then people can see it's explicit. And I think there were a lot of misconceptions going around because people were being told, well, they have no code of conduct.
Misrepresentations, right.
Yeah, so it's a misrepresentation. So I think this is a chance to really set that straight.
And one of the things I was covering the Senate Judiciary Committee hearing where the Democrats were going to say they were going to subpoena some of the conservative allies of the justices. And it was just, this build up, 19-minute meeting. And then all of a sudden they didn't do it. And it was like, what? It was just it was just kind of definitely, Washington politics. Last point on this. Now the liberals, their talking point is that there's no way to enforce this. Is that is there just going to always be the fact that the justices put this out, that's not enough for them?
Well, here's the challenge. We always knew that's the fundamental problem with why the Supreme Court didn't have an official code out there in the first place, because there really is no constitutional way you can have to have someone else getting to pick and choose who gets to sit on Supreme Court cases other than the justices themselves.
Right.
The Constitution says there is one Supreme Court. It means you can't have members of Congress telling you whether you get to sit on cases or not, and you can't have other members of the judiciary getting to second guess that. Because think of how strategically that's going to be abused, right?
Oh, right. Separation of powers issue for sure.
Yeah, and if there were an issue, obviously we don't want justices sitting inappropriately, and if they violated the laws against recusal or if they were doing something that God forbid was actually corrupt, that's where we have the impeachment power. So
exactly,
it's not saying that the justices have no check. There is a check, but it's actually going to be reserved for serious problems, not just partisan politics like we're seeing right now.
Right. I'll move on. The court earlier in November heard an interesting Second Amendment case. I've talked about it a little bit in prior episodes, and it's basically about domestic violence protective orders. A man who was under one, he had a list of other charges, like shooting up different places. So not the best, gun rights activist, right, to come before the court. But he's basically saying, I was under a domestic violence protective order, and I shouldn't be not allowed to have my firearm because of the civil order, right? I wasn't charged or convicted of anything at the time. What did you think of oral arguments on that? Did you think the justices would come out either way, or you think you're going to have a divided opinion?
I thought from listening to the arguments, it seemed pretty clear that Rahimi is not going to probably win this case. And I thought it was a great illustration of how workable the new regime under the Bruin test is. The idea that you have to look back at what was the historical practice and what kind of laws were there. And I think this was a great opportunity. Even the Solicitor General, who herself wasn't arguing for the standard that was adopted in Bruin, did a wonderful job actually of articulating how it can be applied effectively. So this doesn't mean that, were there this type of domestic violence wasn't recognized at the founding or things like that. It was really what did they think? What types of things did they think would be excluded from the people who would have the right to bear arms? And it's clear, it goes way back, that people who were to be considered dangerous and irresponsible would be excluded from that, even if they hadn't necessarily committed a felony, which obviously those someone who's committed a felony also would be, so you can bar them from having weapons, right? So I think she did a great job of clarifying how you can apply this in practice. And I think it shows that it doesn't mean that it's just like free for all, anyone can do anything. No, there actually are standards, and you look at the history, and I think this is what the court's going to do in this case.
Right. And I think some of the progressives, or even Justice Jackson, really was kind of like trying to go after the Bruen holding, right, from last year, where the court basically said any gun control law has to be consistent with the history of the nation's founding, back to the Second Amendment. And they thought this was kind of their best case, since there wasn't domestic violence laws on the book. But as you pointed out, there was history showing that you kept violent individuals from possessing firearms. So I think that I don't see them doing anything to reshape Bruen. Right?
Yeah, I think if anything, this is a chance to kind of illustrate to the lower courts how you go about applying it. And I think Justice Jackson's questioning in particular just illustrated that, again, even the Solicitor General, no conservative, is able to find a way to argue on these things. And she gave some of the strongest defenses of Bruen in response to Justice Jackson's questions. And I didn't see the other liberals really take that up particularly and try to poke holes in it the way that Jackson was. I think they realized, this is how we can apply it. We can make this a very workable test, and let's move forward to try to figure out how to understand the Second Amendment in keeping with history.
Mm-hmm. There's also earlier this month 2 interesting First Amendment cases that were before the court. I thought you and I could touch on them real quick. There was one that was like public officials blocking people on social media. The court didn't really have to get into this with Trump because he left office before they had to take up his case, but there was litigation in lower courts about him having blocked people. This dealt with, I think, one was a city manager, and it had to do with COVID policies, and he had blocked someone. Another case dealt with school board members. What do you make of this whole social media issue becoming before the court? Last term, we had the Communications Decency Act, Section 230, and liability for social media companies. Do you think the Roberts Court is the one having to kind of tackle and square, really, where the internet and the law meet?
Yeah, this is a huge issue now that is becoming so important in our society just because of the growth of social media. And I think the court really is having to be grappling with, how do we apply the First Amendment? Because it's this case which has the one side of if you are the government using social media, how do we deal with that? Does the First Amendment apply like it would elsewhere? I suspect in this case that they're going to recognize that it's challenging, but there is a difference between someone using a government account, which clearly, the First Amendment will be applied to, versus their personal account, even if they're commenting on their judicial or on their government.
Yeah, the justices definitely wanted, it seemed like they were trying to struggle with where to draw the line. I think Justice Kagan said something during arguments, which I led with in my coverage, was basically that this is a hard case because there's First Amendment interests, as you pointed out, on both sides, right? The public officials, but then also those wanting to see the posts.
And there's an interesting kind of parallel cases that are going to be argued as well, having to do with the opposite side. What about the state saying to social media groups, social media platforms, you can't block someone, you can't demonetize
laws
them.
Out of Florida and Texas, I think, is what you're pointing to.
Yeah, exactly. And so you've got the state saying, hey, we want to make sure this is working like a public forum. We should be able to make sure that everyone has a voice. On the other side, you've got the social media companies saying, hey, maybe we have a First Amendment right here to decide what goes on our platform. And so all of those, I just don't think it's obvious where the court is, how they're going to navigate some of this. But we do have to recognize, again, the importance of having First Amendment issues. And then what is the threshold when a group like a Twitter or a Meta or a Google becomes so predominant in the market that they are, by and large, just the forum. And so they can start to be regulated almost like a public utility or something by the state. And it's not just, hey, we can have whatever perspective we want. Once you are that big and that kind of a behemoth that controls the marketplace, do things change?
Yeah. Does once a ruling is issued in these types of cases, are they outdated quite quickly because of like how fast technology moves, do you think? Or is that like what we're kind of like running into? Like it seems like it just seems like a Wild West. You know what I mean?
Yeah, I think the court is going to be cognizant of that and try to outline, principles rather than just specifics. I mean, if the answer is, you can block people on, Twitter but not Facebook, that's not helpful, right?
Right.
I don't think that's where the way the court would do it, but something like that versus, a little bit like we talked about with the gun case, where it's not just this type of specific activity can get you to lose your gun, but what are the broad principles? It's about dangerousness. It's about responsibility. I think the same thing's going to happen here. Like talking about, okay, is keeping up this social media account actually part of your government job, or is it something that you do on the side, kind of just as a separate, more personal thing? Maybe that will be, I think, part of the thing. Is the account owned by your government office so that like that someone else gets elected mayor and they take over the account, kind of like the POTUS Twitter handle,
Right.
I think those kinds of things, because that could apply. You can imagine that applying, to a lot of different types of things, to technology we don't even have yet.
Exactly.
But you can still say, is this a core part of this person's governmental job versus is it an outside thing?
Mm-hmm. There was another kind of funny First Amendment dispute that kind of dealt with like political speech. It was a guy who wanted to trademark the phrase Trump too small. The federal government, ironically, the Biden administration, which is just, this is their job, but it's, like Biden versus Trump, kind of a little funny, is here saying there's a federal law that says you can't use someone's name without their permission if they're living. And I think it's safe to say Trump was not okay with the phrase Trump too small, right? And so this case made it all the way to the Supreme Court. The justices did hear arguments, and it was interesting. I kind of, both Jackson and Gorsuch, not the two separate wings of the court, they both kind of seemed, at least to me in my coverage, to suggest they were going to side with the federal government here. I think Gorsuch said something that there was like a long line of history of not being able to use like another person's name, which suggests there isn't a First Amendment issue. I think Justice Jackson was saying this isn't like saying he can't put the phrase on a shirt. It's more like, he doesn't get the government benefit.
Right. Yeah. Because trademark law isn't, again, it's not just saying you can or can't print this. This is saying this is your company name and no one else can do it. So it's amazing. Even theoretically, Trump couldn't use the phrase Trump too small
right.
if he wanted to. So that I think is different area. And it's a good illustration of, we think of all these big cases that, it's going to be exactly split down the kind of ideological lines of the court. But there's a ton of questions, and not all of them are the ones that the public ends up hearing about. But in most terms, a huge number of cases, normally about 40%, are unanimous. And so that we have Gorsuch and Jackson kind of agreeing on some of the broad principles here, it feels surprising because we're only used to hearing about the divisive cases, but it's really not in the grand scheme of things.
After the Thanksgiving holidays, when the justices return, I think one of the first cases they'll hear in early December is a bankruptcy case dealing with Purdue Pharma. I don't know if you're following that one at all, but I saw something interesting. I thought I just maybe see if you found anything in your news coverage that you might have spotted, but it's just an interesting point. First of all, the Supreme Court, halted the approval of this bankruptcy resolution, right, or agreement. And what I've noticed is like there's victims' families that have kind of filed on both sides of this, right? So like in one instance, there's victims' families who say they're on the side of Purdue Pharma. I guess they're going to be like paying out to communities with this opioid crisis. They want this settlement approved. On the other hand, there's a respondent who was a mom who lost her child who says, even though I guess she's supposed to be being represented by Purdue Pharma lawyers and this whole bankruptcy setup, that she disagrees. She's siding with the federal government, who says, wait a minute, like the Sackler family who owned Purdue Pharma should not be escape liability. What do you make of this kind of interesting, seeing where the victims are kind of coming down, and then also like the court even taking up a bankruptcy dispute like this? What do we make?
Yeah, well, so bankruptcy law is not one of the sexy cases, right?
Exactly.
But they regularly have to take up those types of cases because, there is, as this case illustrates, right, there is a lot of money on the line in these, and there's a lot of really important rights of figuring out who gets in line first when the pot of money that's getting distributed is not going to be able to reach everyone. So everyone's going to lose a little bit here, and it's trying to figure out what the order of operations really is. So it's important that the court take these cases. A lot of times they don't make the front page news, but maybe this one's big enough that people are hearing about it. And I think it also shows you that there's so many of these issues that, it's easiest when you're looking at it in terms of the case to be like, okay, which side do I have more sympathy with here? But it's a reminder that in a lot of these cases, even in the individual case, you can see that there's people, on both sides that you're like, okay, actually, I get why you're sympathetic, and I get why you're sympathetic too.
Exactly.
And of course, remember, this is law that's going to be set not just for this particular case. They don't take cases like that where they're like, let's figure out what should happen with this one company.
Right. It's going to impact all.
They know.
Yeah.
Yeah. And that means companies, sometimes it's going to be companies that it was no fault of their own that they went bankrupt. Sometimes there was wrongdoing. Sometimes it's going to be a small family company. Sometimes it's going to be a giant corporation. You don't know who's going to be the next person. That's really what the rule of law is about. So I'm glad to see them taking cases like this. And I hope they don't get moved too much by just the sympathy card on both sides. Because as you pointed out, sometimes the sympathy card could be manufactured. We don't necessarily know in the moment which side is doing the manipulating and which side is the
exactly.
true sympathetic victim. We need to make sure we're just let's try to look at the facts and maintain a clear mind on this.
Well, thank you so much, Carrie, for your time. Any guess when we'll start to see the justices issue opinions? When do they start usually? Is December, January that we get some out?
Justice Ginsburg was known for being record speed, and she would sometimes even get opinions out as early as November. Mm-hmm. But obviously, she's no longer on the court,
right.
And I think she was an outlier even when she was. So I would think January, maybe December, but more likely probably January. And then, of course, January is also about if there's any more cases being added to the term. Normally, if they don't add them by January, it's going to be hard to get them heard by the end of the term. So I think that's when we start taking a turn from taking a change from the term is just developing to, okay, now we know a little bit of what we're going to see. And also we might even start hearing some actual results. But of course, as you know, the big cases, you probably have to wait till June.
Right before they leave for summer recess, they'll issue those. Yep. Well, I really appreciate your time, and I'll have to have you back to break down some of those major rulings that we get maybe, May, June, we might see some of those.
Awesome. Good talking to you, Alex.
Thank you, Carrie. Happy holidays. Thanks for tuning in to the latest episode of Court Watch. If you have not subscribed yet to this podcast, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.